This is the morning brief from the Economic Times.
There's nothing quite like the unmistakable, soul satisfying crunch of a potato chip. Personally, I can never stop at eating just one. But did you know that there's a lot of science and engineering involved in giving you that perfect crunch? Companies spend millions of dollars in R&D and even create special hybrid potatoes to get this perfect crunch. Companies like PepsiCo, which makes one of the most iconic brand of chips out there, Lay's. But the quest for the perfect crunch landed PepsiCo in a tight spot in 2019. It sued some farmers in Gujarat who, according to it, were illegally farming one of the potato varieties to which PepsiCo owned exclusive rights. But things didn't go as planned for the company.
Due to backlash by farmer groups and political parties alike, PepsiCo withdrew the suit after discussions with the government.
PepsiCo coming out and clarifying after a massive controversy that it will be withdrawing the suit it had filed against four farmers.
And to make things worse, earlier this month, PepsiCo also lost exclusive rights over this particular variety of potatoes. It's almost a David versus Goliath-like victory for Kavitha Kuruganti, the activist who filed the revocation application against PepsiCo's exclusive license.
My main interest was to make sure that no certificate holder of plant varietal protection in India intimidates and harasses farmers, causes confusion in farmers' minds about their rights.
But there is another side to this story also. One of the system failing to provide adequate protection to the intellectual property of a multinational company.
This order may discourage many companies from bringing high yield seeds to India. So, internationally, it is a setback for the country.
It's Tuesday, 14th December, and you are listening to Pepsi, Chips, and a Hot Potato on the Morning Brief. I'm your host, Nehal Chaliawala. In this episode, we will look at why PepsiCo lost its exclusive right to a plant variety that it had created itself. And what does it mean for farmers and license breeders like Pepsi at large? We'll be talking to Kavitha Kuruganti and also Gourab Banerji, who is a senior advocate at the Supreme Court. We'll also talk to my colleague and Morning Brief co-host Ratna Bhushan, who has been closely tracking this issue for the Economic Times. It all began when PepsiCo sued around 9 farmers in Gujarat between 2018 and 2019. It sought over 1 crore rupees each from them in damages for infringing its intellectual property.
It's not exactly a traditional recipe, Pepsi and potatoes, but put these ingredients together and you get a huge uproar. PepsiCo is actually suing 4 Indian farmers, accusing them of growing a certain type of potato that it says is exclusively for Lay's chips.
The company reportedly hired a private detective agency to gather video footage and samples from these farmers. Media reports suggest that these were smallhold farmers who farmed around 3 or 4 acres of land on average. We reached out to PepsiCo for their spokesperson to join us on this podcast, but they declined. In 2019, the company withdrew its lawsuit after it got severe backlash. But the matter didn't end there. And that brings us to Kavitha.
My name is Kavitha Kuruganti. I'm based out of Bangalore and I'm associated with the informal national platform for farmers' rights called Alliance for Sustainable and Holistic Agriculture. We call it Asha Kisan Swaraj. It works for farmers' rights and for sustainable farm livelihoods.
Kavitha filed the revocation application against PepsiCo license as the exclusive breeder for the FL2027 variety of potatoes. The application was filed with the Protection of Plant Varieties and Farmers' Rights Authority, also called PPV and FR Authority. The surprise judgment against PepsiCo came on 3rd December. Do you remember what was your reaction when you heard the judgment?
Well, the judgment came 30 long months after I filed my revocation application in June 2019. And it was a bit of a surprise. This revocation application of mine invoked multiple grounds as to why the PVP certificate, as it's called, Plant Varietal Protection Certificate, that was given to Pepsi in 2016, should be taken back by the authority. And what I didn't expect was that the authority will accept four different grounds on which the certificate given to PepsiCo India Holdings. That was a bit of a surprise.
The Section 34 of the PPV and FR Act 2001 has several subsections that list the grounds on which a revocation application can be filed against a PVP certificate. We'll get back to that. But how exactly did these farmers get their hands on the FL2027 variety? Or FC5, as it is also called? After all, this is an exclusive variety of potato that PepsiCo created itself and it cultivates through contract farming.
So I went to check how exactly FC5 seed moves in this country, a planting material of FC5. So Pepsi does contract farming for some amount of FC5 seed material production with a small set of farmers. And the way Pepsi operates is that it buys FC5 potato from all kinds of farmers, including non contracted farmers. It's contract farming, so called contract farming, in the form of some form of written agreement and so on, is with a very limited set of farmers in Punjab who are into producing planting material. But with a wide set of farmers in India, potato is bought by Pepsi, not even in a bought back mechanism. They just know that a certain set of farmers in Gujarat, in Punjab, in Uttar Pradesh, in Bengal, and so on, they grow FC5 potato, and either they sell it to Pepsi at times that it asks for it and it accepts such material being supplied at its procurement campuses, or the farmers end up selling it to other competitors. So I pointed out that from my visits to these two states of Punjab and Gujarat, that FC5 planting material gets into the hands of numerous farmers through at least four channels.
Kavitha also said that the legal recourse taken by PepsiCo could be a tactic to prevent rivals from getting their hands on this variety.
Remember, Pepsi is not a seed company, and its main interest is not the seed or the planting material of FC5. It was trying to get back against its competitors in Gujarat. There are several Indian companies which are into potato chip production where there's tough competition for PepsiCo, and the competitors have very popular markets in particular pockets of India. And Pepsi wanted to get back at its competitors, and it made a misadventurous decision of thinking that farmers being intimidated and prevented from producing FC5 potato. Remember, they were not producing FC5 planting material. They were producing potato that could be used in potato chip making.
So, PepsiCo sued some farmers and ended up losing the PVP certificate for potatoes used in Lay's chips. That must be a death knell for the company, right?
Absolutely not. It is just one variant among the many for which PepsiCo has IP rights. And in any case, the registration term for this variety was ending on 31st January 2022, which is like 1 month from now. So it is not going to have much material impact on PepsiCo.
That's my colleague Ratna. You heard her voice at the beginning of this episode.
The impact is more notional, and it is more about image, and it also creates a sense of unrest in the industry.
How has PepsiCo reacted to this whole situation?
PepsiCo on record has maintained all along that it is in the process of reviewing the order. And it may be looking to challenge the order legally, but there is no word yet from the company on the same. However, it is a reputational thing, it is an image thing that would impact the company going forward. And it's not just about this variety. So, like you said, there's a bigger picture here. Snack foods as a market is growing very fast in India. There are a lot of giants in this business like ITC, Haldiram, etc., all of whom have specific IPR seed rights. So this creates ripples in the industry about how strong IPR protection is, and people could be just looking backwards if their rights are indeed protected in the long run. Because apart from procuring the rights, companies invest in branding, they invest in backend, and then suddenly the rights are revoked. So the entire process, it is not just about that one variant, it's about the entire strategy which can go haywire.
Strategy is going haywire. So, farmers' rights activists are hailing the PPV and FR authorities' verdict as a huge victory. Corporates are getting jittery. But how big of a victory is it? And is it really that big of a concern for breeders who invest the big money in innovation? I sought senior Supreme Court advocate Gourab Banerji's assistance to help us make sense of the PPV and FR Act and the judgment that the authority gave in a simple language.
Well, this is quite an unusual legislation. It was brought in because we had signed and ratified the agreement on TRIPS, trade related aspects of intellectual property rights. And under that, we were required to bring in this legislation, which we did in 2001. And the title itself is quite interesting because it focuses also on farmers' rights. This is a little unusual, at least internationally. And the coverage is interesting because the preamble tells you what it's really about. The idea is, on the one hand, to protect the rights of farmers, but on the other hand, also to protect the rights of plant breeders, because after all, they are the people who will invest money and encourage the development of new varieties with research, etc. And the entire act, if you see, is this sort of dance between the two, where you have some rights to IP holders, essentially are said to be plant breeders in the act, and of course then you have separate rights given to the farmers.
So, does this lead to some gray area where there is ambiguity on whose rights supersede whose?
Well, the act is unusual internationally because there's really no concept of this balance. But certainly, the emphasis seems to be weighted heavily in favor of the farmer, and the farmer's rights are contained in Section 39, whereas the breeder's rights are contained in Section 28. And it does seem to suggest that the farmers have, if it was a contest, the farmers certainly have a more predominant right, and they can really virtually do anything. They can save, use, sow, resow, exchange, sell this farm produce, including the seed, as long as it's not a branded seed. So, yes, farmers' rights trump breeders' rights to the extent that there is an inconsistency.
So, coming to this particular example, does FL2027 count as a branded seed? And in this particular case, were the farmers wrong when PepsiCo sued them in 2018 and 2019 for selling FL2027 variety of potatoes?
Well, since there was no verdict, we don't know who was right. But the question is, what were the farmers doing? Were they simply selling potatoes as farm produce? Or was it a case where they were marketing, distributing, selling a variety which is registered? So There is a bit of a gray area, which is why probably Pepsi got an injunction before it got settled. So there's really no clear answer as to who was right and who was wrong, and subject to a court. If it gets litigated, we'll know the answer.
Now that Pepsi's PVP license has been revoked, what happens next? Can Pepsi seek legal recourse, and on what grounds?
Yeah. So I've had an opportunity now to read that judgment, and it makes very, very interesting reading. And I have quite a few concerns, doubts, questions about it.
Being?
The application for revocation can be made on various grounds, obviously, which are defined in the Act. And in fact, they're defined in Section 34 of the Act. They tell you, all right, an plant variety certificate can be revoked on grounds A, B, C, D, up to H. And there are various different grounds. One precondition of maintaining such a case is that the application has to be filed by a person interested. Now, that is one area in which the authority has perhaps stretched the phrase a little bit.
According to Gourab, a person interested in this case could be a farmer or another breeder, but not a member of the public. The other reservation he had about the judgment was regarding the grounds on which the revocation application was accepted.
If you read the order in detail, the reason the revocation has taken place is it's taken place under grounds A, B, C, and H. A, B, and C are basis incorrect information. The registration has been granted to a person who's not eligible. The breeder doesn't provide the relevant documents. A, B, and C, reading the order of the authority, I believe that the authority's reasoning is quite strong on this aspect. Assuming all the facts are correctly stated, yes, good reason to revoke. Of course, on technical grounds, which means you can go back and apply again with the proper documentation. So that's easy. But H, which is where the authority has held that there is an issue under H, according to me, is a much wider issue which has much wider repercussions. And H reads that it's revoked, the grant of the certificate of registration is not in the public interest. Please note the words. The grant of the certificate of registration is not in the public interest. What the authority says is, no, after it was granted, Pepsi abused the process. I'm not even going into whether the authority was right or wrong. By filing cases, by harassing farmers, I would say this is a little emotional, and maybe the authority is right to contemplate protection of farmers. But that was not the issue before it. The issue was whether the registration is good or bad. So I really doubt whether the grounds given by the authority on the basis of public interest would be sustainable, because it seems to be a little against the language of the provision.
Given that the PPV and FR authority is quasi-judicial, does this ruling set a precedent?
I'm not sure to what extent a precedent is set, because it is really confined to the facts of that particular case about Pepsi filing suits and withdrawing them. But to the extent it has set a precedent, it's a bit of a dangerous precedent, because surely it cannot be the law that just because you have filed a case which is ultimately settled, you have ipso facto acted against the public interest. That would be stretching the concept of public interest too far. I do think that Pepsi will at least challenge that part of the order before the High Court.
So that's where we are at. Lawsuits against farmers filed by PepsiCo in 2018 and 2019 landed it in a tight spot. The fallout from that resulted in the company eventually losing rights over an exclusive plant variety. While this will have little impact on PepsiCo's business, it does dent its reputation. The judgment is a victory for our farmers. It will be a deterrent to harassment of small farmers by breeders. But it also sets a dangerous precedent. Companies may have to think twice before going to court over the protection of their own IP rights. It also hurts the image of India as a business-friendly destination. That's all from us today. You were listening to Pepsi, Chips, and a Hot Potato on the Morning Brief, with me, your host, Nehal Chaliawala. Producers, Bhavya Dilip Kumar from The Economic Times and Soundarya Jayachandran from Awaz. Sound editor, Swati Joshi from Awaz. Executive producer, Arijit Burman. The Morning Brief airs on Tuesdays, Thursdays, and Fridays. If you like this episode, do share it on your social media. Send us your feedback at themorningbrief@timesgroup.com. That's themorningbrief@timesgroup.com. Happy munching. Credits for all external sound clips used in this episode have been mentioned in the description.